Hello, everybody. Yes, I'm Louise Kennedy, and I'm the Policy and Communications Manager for Victim Support NI. A year ago, at Victim Support's conference, exploring the Gillen Review and where we were at the time with those recommendations and how far we've come, I presented the preliminary findings of this report. Little did I know then that that would probably be the last, I think, public event that I was ever at before the new normal swept across the world with COVID and sort of took away our in-person engagement. So today, after what seems like absolute mountains of data to analyse, looking at observations, opinion, I'm going to present a summary of the full findings. Before I do that, some thanks are in order. This project was only possible thanks to the people who facilitated us in court and helped us process the data, read our drafts. There are just too many amazing people to list, or I really would have us here all day. But I just wanted to make two special mentions in person, and that's firstly to Dr. Leslie Carroll and Dr. Bobby Moore. Leslie was my predecessor at Victim Support, and she started off on this court observer journey, and herself and Bobby continued to conduct supervision, and they produced the phenomenological companion piece to this research entitled Feeling is Understanding. Both those reports will be published this week, and we'll be sending you all out digital copies along with the other resources from the conference during the week after the conference finishes. The second thank you will not be surprising. It's that we owe an absolute debt of gratitude to the people without whom this research would not be possible, and that is the court observers themselves. They dedicated a year of their lives volunteering to sit in Crown courts across Northern Ireland and travel to Crown courts across Northern Ireland to observe sexual offences trials, so that we could learn from what they saw, what they thought, and what they felt. And I'd just like to personally say a heartfelt thank you to them. So with that, on with the report. And if you can just bear with me as I pull up my slides, I'm going to do that now. So let's begin if we can. And of course, I need to hide these meeting controls so I can start my slideshow. Always technical issues, sure. So, what did we do? Well, we recruited 10 ordinary members of the public to observe sexual offences trials across Crown courts in Northern Ireland. They had to have no prior knowledge of the justice system. In short, what we wanted was some fresh pairs of eyes to look at the system and how it worked. This methodology was based off the Northumbria research, the original report, which was commissioned by Dame Vera Baird, who's now the Victims Commissioner for England and Wales and was at the time the Police Commissioner. Observers received training on how the criminal justice system worked in practice, on the principles underpinning it. We gave observers a standard questionnaire to fill out for every trial that they looked at, and we sent them in pairs to observe the trials so that we could balance out and make sure that we were getting a sort of even opinion. We asked them to document what they observed of different aspects of the trial from beginning to end. We did depart from the Northumbria study just a little bit in that we examined not only the treatment of complainants, but also defendants during the course of the study. So between October 2018 and October 2019, we observed 27 trials across all Crown courts, with unfortunately the exception of Derry. We were not able to match observer availability with the trials that actually ended up going ahead in Londonderry Crown Court. So that was one gap, but we did manage to get to every other Crown Court across Northern Ireland, which I was quite pleased with. So what were our findings? From those 27 trials, in a nutshell, this is what court observers told us. They told us that rape myths were widely used and rarely challenged effectively. They told us that there was some evidence of previous sexual history and compensation being raised. They told us that the treatment of complainants in particular during cross-examination was falling short of the dignity and respect that they should be entitled to and are entitled to under the Victim Charter. They told us that failings in technology were doing a disservice to complainant evidence in sexual offences trials, that there were significant delays and adjournments and that this was affecting the administration of justice. and they told us that the questions raised about juror suitability to decide, they raised questions about juror suitability to decide in sexual offences trials in their current form. There were, of course, some positives, and the most common positive was that they concerned judges and their ability to, really their even-handedness, their good explanations, their patience, and their ability to put people at ease during the trials. And particularly, observers loved it when they saw judges providing written routes to verdict and decision trees to aid deliberations, and particularly in the latter trials that would have taken place after the Gillen Review was published. That tended to be something that was happening more regularly. So maybe that's a sign of a bit of change there. So now, any one of those findings could easily take up a full conference by itself, but my time is limited here. So what I'm going to do is touch on some of these highlights in greater detail, and for the rest of it, you're just going to have to read the full report yourselves. So in terms of rape myths, of the 14 trials that reached a stage where rape myths might have been used and identified, and that's complainant cross-examination, court observers identified rape myths in 13. So that's only one trial where they find no rape myths identified at all. The most commonly observed myths were that the complainant's failure to fight or scream indicated that they weren't raped, and that delay in reporting proved that no rape took place. Each of these types of myths were present in 7 of the trials observed. In terms of the sort of why didn't you fight scream myth, the focus tended to be on the reaction of complainants during alleged assaults, and frequently placed responsibility on complainants to vocalise and confirm their lack of consent after the attack had commenced. Those narratives tended to minimise the events leading up to alleged assaults where consent may not have been established, and then they lacked the understanding of how victims classically react when assaulted by freezing or going limp, effectively relying on the jury's ignorance of the body's trauma response. The other myths identified, this is not an exhaustive list, but I'm just going to go through some of them. The victims provoke rape by the way they dress or act. This included accusations that a complainant was flirtatious, that they made irresponsible choices, they chose to go drinking or get drunk or take drugs, and they wore sexually alluring clothing. I'm doing the rabbit ears again myself. Or that complainants had a high sex drive or had previously consensual sex with the defendant, and that demonstrated future or ongoing consent. The narratives often hinted at the complainant being partly culpable for what happened, by acting in a way that meant that the defendant assumed consent, even if that assumption was not a reasonable one. While those narratives weren't so blunt to say it's the victim's fault they were sexually assaulted, they were used to trigger myths which blame victims and excuse defendants for what happened in the minds of juries. In terms of victim blaming, these included that if the complainant had taken action, they could have stopped what's happening. In one trial, this was put to complainants who were young children at the time of the alleged offences, and it made for quite grim reading. Other instances of victim blaming included that they perhaps should have predicted what would happen when inviting the defendant to their home, or that they led the defendant on. In terms of victims who drink alcohol or use drugs couldn't have been raped, and the common argument there was that they would consequently be less likely to withhold consent. They're more likely to consent but not remember doing so, or that in any event, their recall of events is not reliable. In one trial only was the question of whether a blackout drunk person was capable of consenting raised. And in one trial, there were frequent accusations of drug taking, even though all lab tests showed that no drugs had been taken. The myth of if no injury or violence happened, then no rape could have taken place. Sometimes, even when violence did take place, this was raised. In one case where the complainant said she didn't fight because she thought the defendant had a weapon in his hand, the defence barrister actually said, but he didn't do anything with it, did he? As if the threat of violence was okay. You can tell if someone really has been raped by how they act. The myths that tended to be raised were not reporting immediately, saying if you were really raped, you'd remember certain details, making assumptions about how a victim might act around a perpetrator in the family, assuming you would cut them off immediately instead of keeping silent or keeping the peace. you can't be raped by someone you are or have been in a relationship with was quite common in the trials where parties had been in a relationship with each other. In 4 of those 5 it was raised. Defence counsel made some sort of suggestion that a rape couldn't have taken place as they've been in a relationship. 2 of those cases involved allegations of previous or ongoing physical violence or domestic abuse against the complainant by the defendant. And what's worrying there was the absence of recognition of how abuse and coercive control affect the capacity to consent. Now, it's possible that this will change when the domestic abuse bill comes into effect, but it's something that warrants certainly further monitoring and exploration. And finally, the good character and background of the defendant. And bad character and background of the complainant. And this usually involves saying that a defendant who was a pillar of the community or had a job or had no criminal record or was a perceived high social class couldn't be a rapist. It was contrasted then with complainants who had maybe social service involvement, were from a quote unquote bad family, or were single mothers, or who had a criminal record themselves, and saying they probably weren't raped because of this. So that's really a summary of the broad rape myths that were identified. We also asked observers to tell us whether there was anything done to dispel those myths. And this is what they have said. In 3 trials, prosecutors intervened at the time when they were raised. For the most part, those interventions appeared to be limited and did not appear to explicitly characterize what was said as a rape myth or stereotype. In 1 trial, a judge intervened at the time. In 3 trials, prosecutors may have dealt with rape myths during cross-examination. I suppose I say may because they weren't always direct challenges to rape myth narratives, but more indirect approaches. In 4 trials, prosecutors dealt with rape myths during cross-examination of the defendant, and that tended to be more direct when that happened. In 5 trials, the prosecutor made reference to the existence of rape myths or stereotypes in their opening statement. Positively, of the 13 trials that reached the point of the judge summing up, observers noted the use of directions as set out in the Crown Court Compendium and so forth, relevant to the trial in all of them. And in 2 cases, an observer opined that the judge had used or endorsed a rape myth themselves in summing up, and that they felt this biased the trial in favour of the defendant. I suppose it's interesting to note there that that wasn't always fully endorsed by the other observer. It wasn't always corroborated, and there's more detail in the report on that. So in terms of rape myths, observers were critical of instances in which they felt they were, first of all, critical of the usage of them, the widespread use, but also critical of instances where they felt that there really should have been interventions but weren't. Mostly they just could not understand why rape myths weren't immediately and robustly challenged at the time. And they felt that by failing to challenge them and leave them sort of hanging in the air throughout trial, that those myths were tacitly then being accepted as truth or valid evidence. Just a quote there, just the fact that no one refutes the rape myths there and then, why wait until summing up? And in terms of our analysis, we recognise that the determination of what constitutes a rape myth and the influence that such myths have on jury deliberations is very difficult to quantify, particularly because we can't ask juries ourselves. In terms of this report, it can be challenging to discern what constitutes a rape myth, what is a valid comment pertinent to a case, and what is a mix of both, with rape myths sort of interwoven into the narratives that are then justified on the grounds of relevance to a case, which was really, I suppose, the most common, I think, way that they would be presented. This is really a challenge that was posed to our observers when undertaking their work, and it is a challenge faced by our judges, prosecutors, defence counsel, and most significantly, juries every day in the courts. And this is where I think that the value of the Court Observer Panel really shines, because they, like juries, comprise of ordinary members of the public who will most likely be seeing these things for the first time. Now, on one hand, because observers were given a bit of training around rape myths before they embarked on this journey, you could see the frustration where myths were used or went unchallenged, or if they thought they might have influenced verdicts. On the other hand, it is true to say that sometimes observers held differing opinions themselves but between the two on what constituted rape myth even after receiving the training. And I suppose that raises the question, is brief training or education on rape myths sufficient to undo a lifetime of unconscious bias and messaging that reinforces them? Will current proposals under the Gillen Review and so forth to educate juries on rape myths and unconscious bias be effective in an effort to minimise the influence that such myths have on trial. And that's just something I think that we have to, be vigilant about and always be asking ourselves that question. So our recommendations on that are to, first of all, and this kind of flows through the whole of the report, implement the recommendations of the Gillen Review in full. We've also recommended that the PPS should review their policy and practice for challenging rape myths within sexual offences trials, that there should be standardised thorough educational materials on rape myths for all jury members in sexual offences trials, and that the effectiveness of those should be monitored. Research into how Northern Irish juries deliberate in sexual offences trials with a view to identifying if rape myths are influencing design or decision making. And if the research confirms that rape myths continue to influence the process, reconsider the suitability of jury trials in these cases. And obviously we get that, there are laws around, access to juries. So there really does need to be some creative thinking around how that can be done. And finally, review guidance for defence counsel relating to the use of rape myths. And one of the things that were recommended by the court observers directly was consider enforcement measures or professional fines in cases where such myths are persistently used in spite of judicial direction otherwise. Relating to that is our chapter on dignity and respect. And it's the video at the break talked about this a little bit, because under the Northern Ireland Victim Charter, victims of crime are entitled to be recognised and treated in a courteous, dignified, respectful, sensitive, tailored, professional, and non-discriminatory way. Defendants too have a right to expect a fair trial and fair treatment in court, and that's part of a wider suite of rights of a defendant to a fair trial, which are enshrined in international and domestic law and really form the cornerstone of our legal system. What we asked observers to do was record how they felt both complainants and defendants were treated during the trial, and really the overwhelming evidence was of a culture of ill treatment of complainants in sexual offences trials, particularly at cross-examination stage. I have the other fuller, recommendations, but at the moment, given the shortage of time, this is the highlight that I want to go through. So I have plenty of time to give you the main takeaway. It's relevant that of all the trials where there was cross-examination of a complainant, in only one of those cases did both observers comment that the defence barristers treated the complainant with dignity and respect for the entire duration of the trial. And that is, for me, quite shocking and disappointing in terms of an outcome. The main forms of disrespectful behaviours identified included aggressive or harassing questioning, overly persistent questioning, cruelty or insensitivity during questioning, persistent accusations of being a liar that were particularly unreasonable, sarcasm, mockery, belittling complainants, raised voices and shouting, victim blaming, and unreasonable attacks on a complainant's character. I thought the best way to share what observers saw in these cases was to simply quote them directly, to be honest. So I'm just going to read a selection of comments that just kind of, I hope, distill down what observers saw and what they felt about treatment of complainants during their cross-examination. So there was nothing respectful about this questioning, absolutely oppressive and set out to infuriate and belittle the witness. The defence was screaming at the complainant and constantly saying the complainant was a liar. It got to the stage where you could hear the girl crying and shouting in the live-link room because she felt she hadn't protected her little sister adequately. The defence barrister then complained to the judge about her behaviour on the stand. The same questions were repeated over and over again. The prosecution and the judge constantly had to intervene over the way questions were put to the complainant. The defence did seem to get away with too much and seemed to ignore all of the warnings given by the judge. The complainant was bombarded by continuous accusations of being a liar. The defence did not hold back and was pointing fingers through the screen towards the complainant. A lot of the defence barrister's questions were about why she hadn't volunteered information during the ABE. Basically, why didn't the witness answer questions she wasn't asked? Why didn't you see the gap in evidence and volunteer this information? The defence QC constantly called the complainant a liar and accused the complainant of leading the defendant on. The complainant's state of dress was called into question, implying that she had clearly wanted sex by how she was dressed. So that is, the quotes that have come out of it. I do urge you to read the report in full to sort of see what was observed and the nuances in there. but I think it's fair to say that those are pretty shocking comments that were provided by observers. The other side to this, of course, is interventions. What were there interventions from either prosecutors or the judge when such disrespectful treatment was happening? And observers' consensus on this was pretty mixed, much like in rape myths. In terms of interventions, observers felt that there were examples of frequent interventions, there were some of occasional interventions, and there were instances in which no intervention took place where the observers, felt there really should have been. So overall, observers were more critical of prosecutors in failing to intervene, feeling that they weren't fulfilling their role of seeking the court's intervention where questioning is inappropriate or aggressive, which is a key commitment of the victim charter. So to our analysis there, as you know, it is possible that given our justice system is adversarial in nature and leans towards the histrionic at times, that such behaviour is just simply accepted by professionals as the way things are. However, you know, as outsiders, these observers, unblinkered by the familiarity or complacency that we as practitioners and professionals might have built up, they've registered their shock and distaste for what they see as really a toxic culture of disrespect towards some of the most vulnerable complainants in sexual offences trials. Following the Gillen review and ongoing work to implement its recommendations, it's also clear, obviously, that the status quo is no longer acceptable. The cultural change must happen, and because ultimately victims have the right to, and complainants have the right to, expect to be treated with dignity and respect. So our recommendations there were that training for all practitioners on the impact of trauma and rape myths should take place. Review the bar code of conduct in light of the observations reported here and the evidence of the Gillen review. Introduce pre-recorded cross-examination of complainants in all sexual offences trials and require establishment of ground rules and agreed questions before cross-examination takes place. Separate legal representation for complainants to act as a safeguard against disrespectful treatment, and specialist training for counsel and interventions relating to disrespectful treatment and use of rape myths in sexual offences cases, and a requirement for training to be completed if counsel are to work on those cases. The next bit I want to sort of take you through is about juries. Sorry, excuse me. It's about technology. And really, again, this was another area in which there was widespread sort of disappointment and criticism. There were widespread technical issues featuring in almost all the trials that were observed in 14 out of 16 cases that got as far as some sort of technology needing to be used. AB recordings were the biggest identified issue, and of those 16 trials that featured an ABE, 13 had audio or visual issues in which observers felt impeded the evidence. In 4 trials, the audio was so bad that the trial had to be stopped so transcripts could be printed for the jury, which obviously means they were looking at transcripts and not looking at the screen to see the facial expressions and the visual evidence. Other technical issues that arose were that they weren't able to see complainants properly through the live link video, that the live link wasn't working, that acoustics in court made it difficult to hear what was going on, that the AB just didn't play, causing trials to be stopped altogether, sometimes for the whole day until the issue was fixed, and that there was an incompatibility between PS9 and court technologies. Observers felt that they were really concerned that these issues might materially impede a juror's ability to understand or examine the evidence effectively, given that this is, you know, the evidence in chief of complainants. And there were concerns that those failings created a negative perception of whether justice was being done, particularly when an ABA evidence was perceived as poor compared to the quality of other evidence given in court. One said, "It's unbelievable that this is tolerated. Where is the remedial action on this? I've been observing for nearly a year and there has been no improvement. Why is this fundamental not fixed? Unacceptable." So that is really about all technology, and our recommendations are that an integrated audit of police and courtroom equipment should take place. Equipment should be procured that is fit for purpose and compatible across all police stations and courts, and the agencies' equipment should be compatible with each other. Police officer training to record ABEs that meet adequate standards. Consider employing specialist audiovisual engineers or redeploying tech staff within both PSNI and the court service. Produce guidance for recording ABEs, which might include information on, for example, the rule of thirds, a zoom function, miking up a room, how much of a witness's body should be included in a shot, and advice on recording audio, and put in place quality assurance framework and processes, which encompass both PSNI, PPS courts, to ensure that AV video is of an adequate standard and is checked as part of pre-trial case management. So yeah, I'm going to move on then on juries, and this is going to be I think possibly the final one that I'll touch on, because I'm running out of time. But the reason I wanted to highlight this one is because the conduct of juries is not really something that arose in a significant way in the Northumbria research, and nor was it something that we expected observers to comment on in the manner that they did. But they did, even though we didn't ask specific questions about the conduct of juries or their observation of it. Observers volunteered that information in narrative, so we felt that there was enough of it independently that we should include a chapter. Observer views of juries were mixed. They included both explicitly positive and negative comments about conduct. The majority of comments were, however, negative and raised concerns about both jury conduct and how the trial system is set up to facilitate jury decision making. Observers commented that they commented on a number of key themes: jury inattentiveness, whether a jury of ordinary people without legal expertise are necessarily equipped to make decisions on complex legal issues, including the understanding of the burden and standard of proof, how evidence is presented and whether it's accessible to juries, composition, I think that was in terms of gender mostly, jury commitment to the process, and the potential for bias based on a person's appearance, demeanour or background. So just to say that the number of cases in which juries were observed, or members were observed to be inattentive, distracted, disengaged, bored, or even asleep was 11, which is a significant number of trials out of 27, given that some did not reach past the first 10 minutes. Now, of course, it's not possible to ask jurors how they felt, thought, or acted during the trials observed, as their deliberations are privileged and beyond the scope of this research. However, the observations can't just be ignored or discounted. In some cases, better technology and delivery of evidence will fix the problem, and the full implementation of the Gillen Rule will certainly improve matters. But this is something that shouldn't be shied away from, because the lives of both defendants and complainants are in the hands of juries, and they need to be up to that task, especially with the difficulties posed by sexual offences trials. So our recommendations there were consider allowing the jury time at the beginning of trials to ask questions to ensure their understanding of proceedings, what is expected of them, and what the charges or indictments mean. Consider reframing trial formats to replace delivery of evidence by long oral statements to a more multimedia means of delivery, including written and visual aids. Enhance the vocational training for barristers and judiciary to improve quality of evidence delivery to aid jury understanding. There's a lot of comment about dull voices and monotone. And tackle technological shortcomings in the court system to ensure evidence delivered via technology is clear, engaging, and easy for juries to understand. And that sort of links in with our chapter on technology. So I suppose, what do those conclusions tell us? And I'm going to stop sharing the screen because I know that you haven't been able to see my face, and that might be a bit discombobulating. So really, what have we concluded from this? Well, first of all, I think this report and the findings of the observers, the main takeaway is that cultural change is absolutely essential, especially when it comes to making changes about how rape myths are used, disabused, and how complainants are treated during cross-examination. The observers, with their fresh pair of eyes, have told us that our familiarity as practitioners, both in the statutory and the voluntary sector, with the status quo, we have been a little bit blinkered, and that maybe we do not realise just how unacceptable some behaviours and conducts are. The implementation, of the Gillen Review will certainly, hopefully, solve many of these issues, and obviously full implementation is what we should be aiming for. But I think we need to remain vigilant and outcomes focused. What we do isn't the point and isn't the important thing, it's that it has the right effect. And if the reforms that we put in place don't make things better for victims at the end of the day, so what? We might have done all the work, but it hasn't had the effect. we have to collectively put our egos in our back pockets, I think, and never lose sight of the fact that we're not talking about processes or statistics, we're talking about people's lives here. And if our efforts don't have the impact we hoped, we need to pick ourselves up, dust ourselves off, and get trying something else until the outcome matches the efforts. So I hope that this report and the work of the court observers is helpful in that journey, because it is something that we are in the middle of and ongoing together. And certainly Minister Long had mentioned like a lot of the work that is being done by the department, and victim support are one of the organisations involved in that work as well. And I hope that the court observers, their report provides us with a real reminder of the real life experiences of victims and what is really at stake if we fall short in our efforts. So I'm going to leave it there, and I'm going to have a little dip into the Q&A and see if there are any questions that I can answer. I've got about 4 whole minutes left. So let's have a look to see what has been said. I've got a comment from Richard saying he'd like to commend victim support on the crucial and enlightening research, highlights so much of what is wrong with the criminal justice system in these cases. What are the next steps? For example, how will the findings be further disseminated? Well, Richard, we're hoping to publish this report this week, and we will send out, like I say, copies to everyone. We are also obviously, we have an independent advisory group who've actually assisted us throughout this, and that has members of different parts of the justice system on it, and they've received copy as well. And I think as part of our new way of doing things post Gillen, there is an appetite for change, and certainly we will be making sure that the report is in the right hands. We'll be talking with those statutories. We'll also be talking with other voluntary organisations about, what they've seen, and if those observations match up with some of their anecdotal experience on the ground in terms of lobbying work. But certainly, we're not one, especially given that this has taken a year of my life to put together. This is not going to gather dust on a shelf, and we are planning to make sure that the report stands as an independent bearing witness, which is why we're calling it bearing witness to what is happening and what has been happening in our courts for victims of crime. I have a question from Katie, who asks, do you know how this study compares to the Northumbrian study? We basically modelled it off Northumbria, and we also asked Olivia Smith, who her work Northumbria is based on. She gave some training, so we kind of tried to model it a little benchmark in terms of asking similar questions, but like I said, we did depart a little bit because we wanted to also include the defendant and how they were treated. And I know that's something that I haven't really touched upon, because the findings were that for the most part the treatment of defendants was reasonably neutral. There were some criticisms about some slightly persistent questioning, but a lot of those were caveated by well, it was reasonable because he was accused of being a liar, or she was accused of being a liar. It was he in all cases where there was a cross-examination, but he had been caught in a lie, things like that. Also, there was recommendation that perhaps something a little more than just speak into the mic would be good, like some, a more explanatory process for defendants as well. But that was, there wasn't too much that came out of that. But again, I encourage everyone to read the report. Let me see. Emma says, having also witnessed cases, I find it interesting the focus is always on training juries when legal teams and judges are often the people bringing rape myths into the courtroom. How do we prevent this? So I suppose that is the difficulty, because we do need to, training is essential, and training is one part of it, but it's the commitment to cultural change, and it's calling out, and I think having the confidence to call out and making it just a procedural thing that is done, if that's the case, I think is really, really important. I realize I'm reaching the end of my time, but we've got a comment from Barry saying it is shocking in this day and age that technology in courts is so bad. And I think everyone recognizes this. Everyone involved knows that this is a problem, and there is work ongoing. But really, I think one of the observers said, "I could have done better with my iPhone." And everyone has one of those in their pockets. So we really, really need to do better, especially because if if special measures are granted, if ABE is going to be evidence in chief, we can't be disadvantaging complainants by their evidence not being of good quality. They need to get a fair hearing, as one of the observers said in the report. I realize that I have run out of time, and I don't want to eat into the last person's speaking time. So and I'll see if I can maybe answer some further questions in the narrative or in the Q&A box in writing. But I do have to say I am kind of on tech control here, so I'm trying to line everything up as well. But I will try and do my best. But look, thank you very much for your time, for listening, and particularly for listening and watching my slides and not seeing my face. I'm sure that was quite strange, but I couldn't figure out how to change it. So thank you very much, everyone.